Good evening, ladies.
Good evening, sir.
Good evening. So, can somebody tell me, right? We were discussing the employment law part 2 and part 3. The all, the important legislation have been compiled, and as two presentation I'm delivering. Could you, could somebody tell me that where we stopped? We started employment law part 2 and part 3. So what is the last note that you have taken? Who could tell me?
We stopped, sir, slide number 22.
Okay.
Today we have to start arbitration.
Okay, very good. Very good. Arbitration. There are two types of arbitration, right? This is, you have to refer to the slide number 19 once again. So what is the mechanism that we can use to settle industrial dispute? One is, if there is an agreement between the parties, I mean the collective, we will discuss it later, right? So we can settle such disputes according to the provisions stipulated in collective agreement if there is a collective agreement. If not, then the conciliation is the major process. The Labor Department undertakes conciliation. Let me summarize what we learned yesterday. Conciliation, is the, the settlement of industrial by mutual and friendly agreement with a view to avoiding litigation. In keeping with section 3, the CGL, right? Just give me 1 second, ladies and gentlemen. Just need to 1 minute. So, even with the section 3, once again, I'm just, I will be discussing here and there the industrial dispute act was, the separately, and then, a kind of a revision, right? And not the same presentation, some other presentation, but all, the informations, the subject matters are same, right? So conciliation is the process. Conciliation means the Labor Department conciliate, samadhana karan. So parties will be asked to come to the Labor Department, and the Labor Department hear the cases, and finally the Labor Department give an instructions, not a decision. If parties agreed, then we sign 12-1 agreement. It is called, the Memorandum of Understanding. Then it becomes a legal document, and all provisions stipulated in that becomes implied terms and conditions of the contract of employment. And the second one is, look, the next one is refer for arbitration. Referring for the authorized officer, it's also a conciliation, no? Right. The arbitration. Arbitration, there are two types of arbitration. This is actually a litigation process. This is not voluntary. This is litigation process. So, arbitration, it contains two parts, two types of arbitration. One is voluntary arbitration, and the second one is compulsory arbitration. What do you mean by voluntary arbitration? you know, why, so let me go to show you some, just one second. Sorry, where is it? Could you just please wait for a while, right? Just wait for a while. I need to bring some other slide to here. Just one second. It is not there. Right. Is that where is? Yes. Let me just one second. Copy and bring it here. Okay, let me section here. Okay, and just paste. Yes. So, ladies and gentlemen, look at this, slide number 20 now, right? This one. Is it visible or not? Is it visible or not? No one is answering.
Yes, sir.
So mechanisms, this slide number, 19, conciliation, arbitration, industrial court, labor tribunal, collective agreement. So the commissioner has powers under sections 2 and 3, according to Industrial Dispute Act. What is the power of the commission? Agreement, settled through agreement. I mean the collective agreement. Conciliation, right? 3.1b and 3.1c. Voluntary arbitration, section 3.1d. The minister has power according to the Industrial Dispute Act, section 4.1 and 4.2. So 4.1 is compulsory arbitration. This is also a compulsory arbitration, right? Industrial court, this also comes under the compulsory arbitration. And LT, last one is LT. So look, right, this one has all things, stipulated in section, slide number 13, right, has been summarized by this slide number 20. So mechanism for settlement of industrial dispute, IDA means Industrial Dispute Act. The commissioner has powers, the minister has, and the labor tribunal has. Commissioner, what is the power that the Commissioner General of Labor means the commissioner? He can settle industrial dispute through the provisions of an agreement, if there is an agreement between parties. And if not, then the conciliation, this is the major part. This is the major part. Okay. So conciliation, right? Section 3.1b means, it can be referred for a authorized officer. Commissioner General can appoint authorized officer and ask him to settle through conciliation. But normally it is not happening. What is happening is, instead of appointing authorized officer, the Labor Department undertakes the 3.1c. The Labor Department undertakes the conciliation, Samatakarana Kriyavali process. 95% or 90%, more than 90% of the cases are settled through this conciliation process. Okay. If conciliation fails, then we need a solution to the dispute, because dispute is live still. It is a live dispute. We need settlement. We need answer for this dispute. So if conciliation fails, then what commissioner can do is, right, commissioner, according to his power, right, he can refer it for arbitration, right? The referring to arbitration by commissioner is named as voluntary arbitration. What do you mean by voluntary arbitration? Voluntary arbitration means disputes referred to by the CGL, Commissioner General of Labor, with the consent of the parties to dispute. So arbitrator will be appointed and matter will be referred for arbitration, right, with the consent of the parties involved in the conciliation, in the industrial dispute. So that is called voluntary arbitration. What is that? Voluntary arbitration with the consent. If parties do not give their consent to refer that matter for arbitration, then commissioner cannot refer it for arbitration. Then what is the procedure? Then matter will be referred for the minister, irrespective of their consent, whether they give their consent in order to refer that matter for arbitration or not. Minister by post can refer that matter for arbitration. That is known as compulsory arbitration. Compulsory arbitration referred by the Minister of Labor to maintain industrial peace, where parties are required to resort the status quo pending a decision. Right? Voluntary arbitrator can be a person agreed by the parties, or if not, nominated by the CGL. Terms of preference drawn by the CGL, means Commissioner General of Labor, and arbitrator is limited to matter arising out of such references. Right? An arbitrator can decide that the matter is not an industrial dispute. Arbitrator, whether there is industrial dispute or not, arbitrator must take all inquiries as may be considered necessary and must take an award, right, that is just and based on just and equitable. Okay. So, ladies and gentlemen, next subtopic is arbitration. Arbitration. So, just 1 second. Right. Take your note, right? If the conciliation process is failed, in settling industrial dispute, in settling, right? Industrial dispute, the Commissioner of Labor has the power to refer such industrial dispute for settlement by, to settle such industrial dispute. Could you kindly, somebody tell me how we started? What we have written down? I mean, the total sentence.
If the conciliation process is failed in settling industrial dispute,
Come
the
on.
Commissioner of Labor has the power to refer such industrial dispute
Has the power.
has the power to refer such industrial dispute.
Such industrial dispute for settlement by arbitration to an arbitrator with the consent of the parties, involved in the industrial dispute, involved to the industrial dispute, involved to the industrial dispute. So with the consent of the parties, that is more important. So underline that one, right? Underline that one. This is called voluntary arbitration. This is called voluntary arbitration. This is called voluntary arbitration. Okay? Right. You know how we started arbitration at the beginning, right? Have I given note? Right now, the arbitration can be divided into two parts. One is voluntary and the second one is compulsory, right? Have you taken note as such?
No, sir.
So then what is the, the topic is arbitration. Then what we have, what is the note that you have taken under arbitration?
If the conciliation process is failed in settling industrial dispute.
Okay, right. So next para. If parties do not consent, parties do not consent. If parties do not consent, do not consent, කැමැත්ත දෙන්නේ නැහැ, right? එකඟතාවය දෙන්නේ නැහැ, do not consent. To repair industrial dispute, to an arbitrator, then the matter will be referred for the Minister of Labour. The matter will be referred for the Minister of Labour. Minister of Labour. The minister as per the section 4.1, as per the section 4.1, as per the section 4.1 of the industrial dispute, can refer such a dispute within bracket, if the matter is minor. If the matter is minor, close the bracket. If the matter is minor, close the bracket. What we said, if can somebody repeat the sentence?
If parties do not consent to refer industrial dispute to an arbitrator, then the matter will be referred for the Minister of Labour. The minister, as per the section 4.1 of the industrial dispute, can refer such a dispute.
Industrial Dispute Act, right? Industrial Dispute Act,
can refer such a dispute within bracket if the matter is minor.
Such disputes to an arbitrator, for the settlement through arbitration
Excuse me, sir. Can you repeat the sentence again? To an arbitrator for the settlement?
through arbitration. Right. Whether the parties give their consent or not. It means that even though parties disagree, to refer the matter for matter for arbitration, minister can do it. But if parties do not agree, commissioner cannot do it. Commissioner cannot refer that matter for arbitration, right? That is why if voluntary fails, then matter will be referred for compulsory. I mean, the minister without whether they give their consent or not, minister will refer that matter for arbitration. This is called compulsory 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 arbitration. Okay. This is called compulsory arbitration. Next para. If the matter is major, if the matter is major, I mean, dispute is major, minister will refer it. For the industrial court, to refer to settle the matter, through arbitration. Right? Through arbitration. In this case, arbitrator must be arbitrator or panel of arbitrators. Panel of arbitrators. In this case, arbitrator or panel of arbitrators.
Sir, will you say it again? In this case,
Arbitrator or panel of arbitrators. Panel of arbitrators. Sometimes we appoint 3 bench, right? A panel of arbitrators. That is also arbitration. Panel of arbitrators must be selected. from the judges, from the judges, from the judges who have been appointed, who have been appointed, who have been appointed. Just 1 second. So in the from the judges who have been appointed to the industrial court, to the industrial court, who have been appointed, who have been appointed to the industrial court by HE the President, by HE the President, His Excellency the President, with the recommendation of, the Minister of Labor. Right. Next
So with the
paragraph. Sorry.
So with the recommendation
of the Minister of Labor. Next para. No more than 5. No, or not more than 5. Judges will be appointed for 3-year period, for 3-year period, for 3-year period in this regard. You know, ladies and gentlemen, you have to understand this one very clearly, right? All the time, we are not appointing judges for industrial court, right? But if there is a very serious industrial dispute in the country, if conciliation fails, then voluntary arbitration also fails. And the matter is very, severe. It has a lot of implications on the economy. In such cases, instead of referring it into an arbitrator may be an outsider, maybe a labor departmental retired person. There is a pool of arbitrators, right, in the labor department. We can pick up, even LT president can be appointed as an arbitrator, and the matter will be referred. But if the matter is very, very, significant, if it has, the serious consequences on the economy and the society, then it means the matter is major. So in such situation, instead of referring that matter, irrespective, without ignoring the consent, whether the worker parties give consent or not, instead of preparing that matter for an arbitrator, selected arbitrator, minister and the labor department will select very, the 3 or 5 people, at least 3, right? Not more than 5 people who have substantial knowledge in industrial relation, and we discuss with them, and with their consent, if they give consent, we write to the president and the minister will recommend. So we have this type of matter, and this matter cannot be settled through normal arbitration. So therefore we need a special arbitrator. So please appoint these 3 or 5, maximum 5 people for 3-year period, right, for the industrial court. So that is the procedure. Then the president appointed. Then selecting at least 1 or 2 or 3 people from that pool, the matter will be referred for them. That is also is known as compulsory arbitration, right? This is also, right, next para, referring dispute for industrial court. Referring dispute for industrial court. Is also a compulsory arbitration. Is also a compulsory arbitration. Okay, right. Let me ask you a practical question. So, disputes can be a live dispute, or may not be a live dispute. Right? Live dispute means still there is an employer-employee relationship. Employer-employee relationship has been broken by either party, then there is no live industrial dispute. Say, for example, right, you will not be treated properly, right, by your employer, I mean in the company. So you feel that, it's boring to stay here, and you retire or resign, sorry. Right, you resign. Then, when you resign or retire, once you retire, there is no contract of employment. So then later you can't go to the labor department and say that, I was arrested, so therefore I had to leave the place, do something. No, you can't do it because you have retired. But when it comes to constructive termination, I will let you know it when we discuss the Termination Act, right? Termination. Then there is a possibility, right? But otherwise, if there is no contract of employment, there is no live dispute as well. So therefore, and if dispute, if there is a dispute in relation to termination of employment, because that, how do we define the industrial dispute? Can anybody tell me? How do we define industrial dispute? Yes? Can anybody tell me? Diniti? Sanduni? No response? How do you define industrial dispute? Any differences or dispute between employer and workman in relation to what? in relation to employment, non-employment, terms of employment, conditions of labor, termination of employment, reinstatement of employment. Any differences, right, in connection with these 6 areas? That is how we define. So let me show you. Slide number 21. Any dispute or difference between an employer and a workman, right? Or between, just simply between employer and workman, connected with the employment or non-employment or terms of employment or the conditions of labor or termination of service or the reinstatement of service of any person. So that is a dispute. So what is the mechanism that we have to settle such industrial dispute? We have very clear provision in the Industrial Dispute Act. Number 1, if there is an agreement between employers and the workers, I mean the trade union, and if such agreement stipulates any provision how to settle industrial dispute, then we have to follow, Labor Department must follow that process and ask them to come to an amicable solution. If not, then the Labor Department, the conciliation process. Conciliation, the authorized officer can be appointed and ask him to, the conciliate, but normally it is not happening. The Labor Department is undertaking industrial dispute as, the conciliation process. Conciliation is, trying to settle this dispute through consensus building, amicably settlement, friendly manner. There is no, it is not, Labor Department should not try to settle through by force. No, friendly manner, right? Then, right? So, if conciliation fails, then the commissioner may ask the parties, hey, look, you are not coming to an amicable solution. So matter has to, now it is my duty to refer this matter for arbitration. Would you give your consent? Would you like to, right, refer this matter for arbitration? Ask the management or the employer and the trade union or the worker as well. If there's yes, okay, we agree. Sometimes jointly they can nominate any arbitrator, right? Or otherwise commissioner can decide. So if they agree to refer this matter for an arbitrator to settle through arbitration. Arbitration is a litigation process, not voluntary. Even though it is a voluntary arbitration, whatever it is a litigation process. So then matter will be referred for an arbitrator. There is a pool of arbitrators in the Labor Department registered. So one of them will be selected and matter will be referred. If parties do not agree, no, we don't like to refer this matter for arbitration, and dragging. But we need to settle as much as quickly. So then the Labor Department, the commissioner, will take a decision. Okay, you do not agree, then I will refer this matter for minister. Minister then, whether they give their consent or not, that is not important. That is not important. Minister, they will refer that matter for an arbitrator. That is compulsory. If my matter is mine, if matter is major, then definitely arbitrators must be selected from the judges of the industrial court. If there are no judges appointed, then procedure has to be started with the recommendation. 3 must be nominated and appointed by the president, and then matter will be referred for them. So that is also compulsory arbitration. Okay, is it clear? Ladies and gentlemen, I'm asking you. You have to answer or respond. Is it clear?
Yes, sir, clear.
Right. Now, So next, next bullet form, first bullet form, arbitrator is not bound by, arbitrator is not bound by the contract of employment. Contract of employment. Arbitrator can decide new terms and conditions, new terms and conditions of employment, new terms and conditions of employment, which will become implied terms and conditions, implied terms and conditions of the contract of employment. Next bullet form, arbitrator must make an award. Arbitrator must make an award. That is just an arbitrator must make an award. Must make an award. That is just an equitable. That is, arbitrator must make an award. That is just an, based on just an equitable principle, just an equity, just an equitable. Okay. Right. Next one, put like this. Give me 1 minute, right? Yeah, there was a very, very important point that I wanted to raise, but I forget. But let me mention it later. It will let me recollect maybe later. Right. So the right. Next subtopic, reliefs that can be awarded by an arbitrator. Relief that can be awarded by an arbitrator. When an industrial dispute is referred for an arbitrator, he investigates it, right? He gathers all information. Finally, he gives an award. Award must be sent to the Labor Department, the Commissioner General. The Commissioner General, right, looks it, and if it is okay, then it will be sent to the parties. Then the parties must settle it as further decision stipulated in the award. Okay, so so before we take note, right, with regard to relief, okay, right, we will put it later, right, just after this one, right? Relief, next subtopic, relief that can be awarded by an arbitrator. What are the reliefs that an arbitrator can award if matter is referred for an arbitration? Right. These are the relief, ladies and gentlemen. Right? What are the reliefs? There may be a number of, I told you, he's not bound by the contract of employment, right? Having investigated everything, so he can make an award. Okay. Relief. Bullet form, first bullet form, don't put number 1, number 2, number 3, bullet or star mark, first one. All wages and right, I forgot to, okay, I will let you know it later, right, after this one, because what I wanted to tell you is very important, right? Once matter is referred for an arbitrator, whether it is compulsory or voluntary arbitration or industrial court, then everybody must maintain status quo. What do you mean by status quo? If, when matter is referred for arbitration, whether it is compulsory or voluntary, when matter is referred for, just once matter is referred for an arbitration, both parties, employer or the management and the workers, they must maintain a status quo. What do you mean by status quo? That is what I wanted to tell you, a very important one. What do you mean by status quo? Only, only this Kavisa, and very few people is responding. No others. Kavisa, what do you think? What do you mean by maintaining status quo? It's must.
I have no idea, sir.
Okay. It means that, okay, for example, right, there is a strike and a strike. Dragging. Labor department tries to, settle it through conciliation, but conciliation fails. And then Labor Commissioner, right, asks the parties, try to refer that matter for arbitrator. Then they do not consent, right? They don't like the parties, trade union people, those who are on a strike, workers, and either party, right? They do not consent. Then minister, Balahatkari, compulsory. So refer that matter, whether they give their consent or not, for an arbitrator. Then both parties, those who are on a strike, the workers and the management, must maintain status quo, meaning that workers must, those who are on a strike, report to work immediately, report to work. Employer cannot harass such workers. The employer must open the gate and accept them as workers until the arbitration award is granted. That is what we mean by status quo. කලින් හිටපු තත්ත්වය මේන්ටේන් කරන්න ඕන. කලින් හිටියේ කොහොමද? ස්ට්‍රයික් එකකට යන්න කලින් සේවකව වැඩට ගියා, ආපුතා හිටියා, වැඩ දුන්නා, ඒ තත්ත්වය තමයි පස්සේ නැති වුණේ status quo කියන්නේ කලින් තිබිච්ච තත්ත්වය maintain. Is it clear now?
Yes, sir.
Right. Right. I will let you know, right, just after this one, with a special note, right, we will take that note, right. Relief that can be awarded by an arbitrator. First bullet, all wages and all other conditions, all wages and all other conditions, all other conditions, or service including for a period of including for a period of strike or lockout, for a period of strike or lockout, for a period of strike or lockout. Right. Number two, bullet number two. Restatement or compensation, reinstatement or compensation, where termination is in dispute. Termination is in dispute. A gratuity,
Gratuity is next one, sir.
yes, a gratuity. If gratuity is not covered by, if gratuity is not covered by, if gratuity is not covered by the Gratuity Act, you know, if his or her or worker's gratuity is covered by the Gratuity Act, no one can, you know, give any decision with regard to gratuity. You have to go by the provision of the Gratuity Act. But the gratuity, the person is not covered under the Gratuity Act, then still he is asking some gratuity. In such cases, arbitrator has some power to determine whether gratuities should be given or not. But if he is entitled for gratuity under the Gratuity Act, arbitrator does not have that power. That is what I'm saying. You know, if you know, gratuity is not covered by the Gratuity Act, right? If gratuity is covered by the Gratuity Act, arbitrator does not have that power because it is not dispute. This law is very clear, right? Next one. Next one. If an order for reinstatement is made, if an order for reinstatement is made But if workman requests, requests an alternative of compensation, the arbitrator shall do so. The arbitrator shall do so. For example, with regard to termination matter, right? Instead of going LT, the person may come to the labor department and ask, then parties will be summoned and asked to reinstate, but not pay, and then the whether it is compulsory or voluntary, a matter will be referred for an arbitrator. Arbitrator will give an order or made his award to reinstate the worker, but worker may not like it. The worker may say to the arbitrator, no, I don't like to work with this man, once again, this employer. Then in such cases, instead of reinstatement, compensation, there is a compensation formula, right? Compensation can be, the granted or awarded as an alternative. Okay. Next. Right. An award must be gazetted. An award must be gazetted. An award is the award given by the arbitrator. An award must be gazetted by the Commissioner General of Labor. Next. Award can be repudiated. අවලංගු කරන්න පුළුවන්. Repudiated. බල රහිත. Repudiated. By giving notice. By giving notice. Notice of 3 months. ප්‍රතික්ෂේප කරන්න පුළුවන්, giving 3 months, notice of 3 months, comma, but repudiation, ප්‍රතික්ෂේප කිරීම, shall not become effective. Shall not become effective. Until after 12 months. Until after 12 months. From the date of award or from the date of award or expiration of notice. Right. So after that, put like this, you know, the very important, right? You have to take note. The word very important and put a dash, very important. Very important. Once a dispute, is referred for arbitration, both parties must maintain the status quo, right? The status quo. STATUS, next word QUO, status quo, right? Pending a decision. What I said, once matter is referred for an arbitrator, parties must restore, restore, restore the status quo pending a decision of the arbitrator. Pending the decision of the arbitrator. Within bracket. Right? Within bracket. Workers must report to work. Workers must refer to work. And employer or the management must allow workers to work. And should not shall not harass them. ඒ මොන වෙනකන්ද decision එක එනකම්. Okay. Now, right. Next subtopic is collective agreements. I'm a little tired, ladies and gentlemen, so I would like to have a break right now. It's 9:10, right? Up to 9:25, 15 minutes, right? We will be having a break because, you know, I had morning, you know, the session and 5 to 7, another one, and just now this one, right? So shall we have a break? 15 minutes now, 9:10. So 15 minutes, 9:20 up to 9:25. Okay.
Okay, sir.
Right. Okay, let's start. Now, I would like to draw your attention to the mechanisms, mechanism of industrial dispute. So, go back to slide number 20. So, what is it? There is a graph, right? Excuse me. Industrial IDA means Industrial Dispute Act. Commissioner has power to settle industrial dispute through an agreement, conciliation, and voluntary arbitration. What do we mean by agreement? It's collective agreement. Now then, we discuss some provisions in relation to collective agreement. Okay. So subtopic is collective agreements. Collective agreement. Collective agreement. So, ladies and gentlemen, before we define collective agreement, we need to understand what do we mean by collective bargaining, because collective agreement is the result of collective bargaining. Collective agreement is the result or effect of collective bargaining. First, you need to understand what do we mean by collective bargaining. Okay, subtopic is collective agreement, right? Under collective agreement, put another subtopic, collective bargaining. Collective bargaining. Okay.
Excuse me, sir, can you spell for the second word?
Collective bargaining, right? BARGAINING. Bargaining. Bargain करना हो गया. Bargaining. Head to करना हो गया. सामूहिक केवल किरी. Collective bargaining. Subtopic is collective agreement. Samuhika givisuma. Right. Under that one, another subtopic, collective bargaining. Samuhika keval kiri. Singaling apike. You know, ladies and gentlemen, in order to determine terms and conditions of employment, within the context of Sri Lankan labor law, we have a couple of mechanisms. One is we have Minimum Wage Act number, the initial one, 3 of 2016. Then it was amended in 2021 as well. Right? I don't remember the exact number, but 2021, amended one. 12,500 is the minimum basic salary. On top of that, we have wages boards established under the wages boards ordinance to determine terms and conditions, including wages and salaries. On top of that, we have voluntary process to determine terms and conditions of employment, including wages. That is called collective bargaining process, leading to collective agreement. That is the superior. Within the strata, That is the top. And then wages sports, and then finally the minimum one, Minimum Wage Act. Okay, right. This collective bargaining and collective agreement, those are voluntary process. We have around 100 collective agreements so far in Sri Lanka in operation. Right. Most of the collective agreement, they have set out. The collective agreements have set out the higher terms and conditions of employment, which are more, which gives more benefits, which give more benefits to the workers. So then, what do we mean by collective? Collective agreement is the result, ladies and gentlemen. First, we start as a collective bargaining. No, the trade unions representing the workers in a particular organization or a sector, they prepare an agenda, right, to discuss with the management or employers, right, in terms of determining, salary increment, overtime payment, holiday payment, leave, right? The agenda includes, anything relating to terms and conditions of employment. You studied, already, right? What do you mean by terms of employment? When you study the, the Sopan Employees Act, I have already informed you. I have asked you to take note, and the conditions of labor as well. So the trade union, not individual workers, trade union representing the workers, they prepare agenda how to increase wages during the next couple of, the two years, and how overtime should be paid. What are the leaves entitlement? Right? They discuss. That is a process. They discuss with the management, sit down, and in order to give some legal, how can I say, legal background or legal authority for them to discuss with the management, we have legal provisions, right? In the Industrial Dispute Act, giving recognition for the trade union to discuss with the management. Okay, we have amended Industrial Dispute Act number 56 of 1999, the amended one. Still, we are discussing the Industrial Dispute Act. And there is one condition. If any trade union has 40% threshold, meaning that the trade union X operating in the company Y has 40% membership, right, within that, of the total employment within that, organization, the trade union X has 40% membership. So if they have 40% membership, and when such trade union requests the employer for collective bargaining, the employer cannot refuse. Employer cannot refuse. They have to adhere. You may be having a question that, how do we determine the 40% threshold? Trade union say, yes, I have 40%. Employer says, management says, no, he doesn't have. That trade union does not have that 40%. Then the labor department, the request may come either from the trade union or the management to undertake a referendum in order to ensure that the said trade union has 40% threshold or not. Then the Labor Department, once such request is received by the Labor Department within 1 month, right? There is a procedure, right? So undertake a referendum within 30 working days. Undertakes a referendum. Rahas Chandya. So then the workers vote in favor of trade union or against trade union. If such trade union has with the referendum, right? Referendum ensures, if the referendum ensures that the trade union has 40% membership of the total workforce in that organization, then employer cannot refuse the bargaining. So legal background has been provided. Legal provision is there. Otherwise, it becomes unfair labor practice, of which, in which, in that case, the employer will be punished. Okay, right. Subtopic: collective bargaining. Okay. Collective bargaining is the process of collective bargaining is the process of collective bargaining is the process of voluntary negotiation between employer stroke management, between employer or within bracket management, between employer within bracket management, close the bracket, and workers within bracket trade union within bracket trade union, close the bracket, without the intervention of the government, 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 put a bracket, and within bracket, Labor Department or Commissioner of Labor, close the bracket. Commissioner of Labor, close the bracket. In relation to terms and conditions of employment, terms and conditions of employment, including wages, terms and conditions of employment, including wages. With a view to grant, not grant, with a view to provide favorable benefits to the workers. right? Next bullet form. An organization such as the employers apostrophe s, after s apostrophe, the employers federation of Ceylon, the employers such as the employers federation of Ceylon, EFC, and trade unions may act ACT act, क्रियात्मक act as negotiators or facilitators, in this process. Next subtopic, collective agreement. What we have discussed so far is collective bargaining. Next subtopic, collective, under the collective agreement, I ask you to have another subtopic, collective bargaining, and next one is collective agreement. A collective agreement is the result or fruit result of the process of collective bargaining. Through the bargaining process, parties come to a level of agreement, agreement. Then the parties will sign. Then the parties will sign an agreement stipulating the agreed terms and conditions of labor. Stipulating the agreed terms and conditions of labor. Subsequently, it will be sent to the Department of Labor subsequently, it will be sent to the Department of Labor to verify the terms and conditions of employment, the terms and conditions of employment, the terms and conditions of employment stipulated in the collective agreement are in consistence, not inconsistent. In is one word, in consistent, another word, consistent. Consistent, අනුකූලද, එකඟද, consistent with the labor law in the country. With the labor law in the country. Next, sorry, continue. Full stop. If it is okay, I mean, fulfill the requirement. If it is okay, the collective agreement, right, is, if it is okay, the collective agreement must, not is, must. Must register, must be registered by the Commissioner of Labor, by the Commissioner of Labor by publication in the government gazette, to give legal effect, to the terms of such agreement, to the terms and conditions, of such agreement. Okay, I hope you understood. You understood what I said. Right? Any questions so far? Do you have any clarification or question? You know, just looking at Badiku's presentation, you can't get more idea. You have to listen to the presentation because I'm explaining more than they are in the presentation. Okay? Any question? Did you understand? Let me ask, put the question in some other way. Very few participants. Everybody has gone. Is it clear?
Yes, sir, clear.
Okay, right. Next subtopic, labor tribunals. I'm once again going back to my slide number 20. Number 20. Look at this one. We have so far discussed. Agreement means collective agreement. Okay, right. Before that, so before you write labor tribunal, right? Next one. Put a star mark, right? Tarulakunadan star mark and a star mark dalalian. If such collective agreement, has provisions in settling industrial dispute, Commissioner of Labor according to the provision, according to section 3 within bracket Roman 1, again within bracket simple a, according to section 3(1)(a). 1 is Roman within bracket, a also simple a Roman within Roman bracket. So within bracket, sorry. Of the Industrial Dispute Act. Could you, please tell me how we started, what you call this sentence?
If such collective agreement has provision in settling industrial dispute.
Provisions in settling industrial disputes, comma, then
Dispute Commissioner of Labor according to section 3 Roman 1 A of the
this Industrial Dispute Act has the power to settle industrial dispute dispute as per the provisions, as per the provisions, as per the provisions, as per the provisions stipulated in the collective agreement. Stipulated in the collective agreement. Okay. Now, again, right, we need a small break, right? So, just 5 minutes. Now it's 10 o'clock up to, 5 past 10, right? A small, very small break, okay? Do you agree or not?
Yes, sir, we agree with you.
Okay, okay, right. Just 5 minutes. Okay, right. Let's start. Now, we are moving to the final part of the mechanism of settling industrial dispute. I'm going back to, right, just give me 1 second, right? My light is not. Okay, I'm going back to my slide, right? Number 20 now. Look at the, the last part. We discuss the power of the commissioner, settlement through agreement, conciliation, voluntary arbitration, and the minister's power, compulsory arbitration, and repairing matter for industrial dispute, industrial court, and then final one, LT, right? Part 4A of the Industrial Dispute Act, Labor Tribunal. Okay, right. So, ladies and gentlemen, next subtopic is labor tribunals. LT. Kamkaru Vinishya Adhikariya, labor tribunal. Remember, right? According to the provision of the Industrial Dispute Act, if your employment is terminated by your employer within 6-month period from the date of such termination, you should go and you should make an application to the labor tribunal. Normally, there are provisions to address such issues through conciliation and arbitration as well. But if it is, the dispute is relating to termination of employment, better to go for labor tribunal if such termination is not covered by the Termination Act. If your termination is covered by the Termination Act, the next topic, Termination of Employment of Workmen Act, then you can go to labor tribunal, but no harm. But the speedy process, in order to speed up the process, you have to go to report to labor department if your termination is covered by the Termination of Employment of Workmen Act. But in general, remember, if your employment is terminated, you can go to labor tribunal. You can make an application to the labor tribunal. In any case, whether your termination is covered by the Termination Act or not, there are certain terminations, certain aspects of termination which are not covered by the Termination Act. In such cases, definitely you have to go to labor tribunal. That is the best way. Instead of, complaining the labor department, conciliation, arbitration, no, right? Go directly. If termination, go directly to labor tribunal. If your employment is not termination is not covered by the Termination Act, I will let you know what are the aspects of termination that are not covered by the Termination Act in my next presentation. Not today, the next day presentation. Okay, right. Labor tribunals, subtopic, labor tribunals. You have to go within 6 months. Otherwise, it becomes, you know, non-live industrial dispute. You have to have live dispute. If you do not go with, you know, before 6 months, then you will be in trouble. Okay, right. Say, let me tell you. According to the provision of this Industrial Dispute Act, if your employment is terminated by your employer, either on disciplinary ground or whatever it is, you can make, you or on behalf of you, if you are representing the trade union, your trade union can lodge a complaint or made an application to the labor tribunal within the 6 months from the date of such termination. Okay, right. Take your note. Labor tribunals, the topic. First bullet form. Right. A workman stroke. A workman, O-R-O, not a stroke, O-R-O. A trade union, a trade union. A trade union. On behalf of the member, comma, may, M-A-Y, may make an application in writing to a labor tribunal for relief, for seeking relief, සහනයක් බලාපොරොත්තු වේ. Or redress. In respect of any of the following matters. Simple A. Or you can say 1, 2, 3. You can put 1, 2, 3. Oh, simple A. The termination of the service of a workman. The termination of the service of a workman by his stroke her ගෑනු හෝ පිරිමි employer within 6 months of within 6 months of such termination. Within 6 months from the date of such termination. B or 2. The question whether any gratuity or other benefits are due to him, from his employer, his or her employer, on termination of the service, on the termination of service, and the amount of such gratuity right, full stop, within bracket, if gratuity is not covered by the Gratuity Act. If gratuity is not covered by the Gratuity Act. If it is covered by the Gratuity Act, Labor Tribunal does not have power. But remember, right, Labor Department is in the process, it was in the previous, the period, Labor Department is in the process of, piling all cases in relation to any matter with the Labor Tribunal, right, where, right, there is no magistrate courts in a particular district. If there is no, it's like this, all cases, right, now in the future, it is being, legislation is being amended, legislations are being amended, right, enabling the Labor Department file all cases with the Labor Tribunals. If there is no Labor Tribunal in that particular area, then it will be filed with the magistrate court, right? I will let you know it later, right, once the legislation or amendments are being made. Okay. Number 3. Such other matters relating to the terms of employment or the terms of employment or the conditions of labor of a workman as may be prescribed next bullet form, right? Ladies and gentlemen, the labor tribunal, right, can grant relief, right, to a workman upon an application made subsection 1 or made, right? Forget about subsection 1. Notwithstanding, mean anything to the contrary in any contract of service between him and his employer. In other words, LT can ignore contract of employment and give some relief to the employee, right? In simple way. Next bullet form. The LT can ignore, we will take, the simple note. The LT can ignore. The LT can ignore the provisions of the contract of employment and give some relief to the employee. Next bullet form. LT must hear all evidence and make an order which is just and equitable. යුක්තිය සහ සාධාරණත්වය මත පදනම් වූ තීන්දුවක් දෙන්න ඕනේ. Okay. Ladies and gentlemen, look at this one. Methods of settling the dispute by the commission. Again, I'm recalling your memory. The complaint received by the commissioner can be categorized into or put into two baskets. One is complaint in relation to statutory rights. For example, salary has not been paid. EPFO gratuity has not been paid. Budgetary relief and holiday payments have not been paid. These are not actually disputes. Sometimes we call this a statutory violation of statutory rights. Sometimes we may call it statutory, right-based dispute. Right-based dispute. Those are actually not disputes. All these disputes relating to statutory rights cannot be investigated, cannot be conciliated, cannot be referred for arbitration, right? Cannot be referred for LT, right? Because those are under the Industrial Dispute Act. because these are violation of statutory rights. People used to call it right-based, but those are not disputes, violation of rights. So the all complaints received by the Labor Department put into two baskets. One is this one basket is a statutory rights basket. The another one is a non-statutory rights basket. So if it is anything relating to statutory rights, right? So ladies and gentlemen, give me 1 minute. Ladies and gentlemen, so any dispute relating to violation of statutory rights, we can't follow the procedure stipulated in the Industrial Dispute Act, because if it is non-payment of EPF, we have to take action according to the provision of the EPF Act. If it is non-payment of gratuity, we have to take action against action, right? According to the provisions stipulated in this Gratuity Act. If it is salary, under the Wages Board's Ordinance and Open Office Employees Act, under the Budget Relief Act. So there are some disputes which are not violation of statutory rights. Example, increments has not been given. Increment is not a statutory right. No. And bonus has not been given. Salary increment has not been given. Attendance incentives has not been given. So something like that. Those are non-static. Those are what we call interest-based dispute. These are the actual disputes that we must address, right, according to the provisions of the Industrial Dispute Act. So conciliation, arbitration, labor tribunal, etc., etc. Okay, right. My next slide. Enforcement mechanism. Dispute arises, non-statutory disputes. Settlement by the commissioner. If failed in go to arbitration, the award is whether it is compulsory or voluntary. Then award is granted. If not compiled, if employee is not adhering to the award, then filing the case in the magistrate court by the commission, right? Or otherwise, the employer can, on the conviction, fine up to 5,000 rupees and 1 year imprisonment or both. Or on the other side, against the decision of the arbitration award, the employer or the worker, right, if he or either party is not satisfied, unsatisfied party can go for a writ application and to the Court of Appeal, right, and then appeal to the Supreme Court. So this is the procedure, ladies and gentlemen. So now, right, I have to stop right now. We will start from slide number 30, right, from next day onward. So far, what are the questions that you have? To be started from, employment law, part 2, up to slide 29. Okay, right. So what are the problems or questions or any clarification do you have so far? Sanduni, is it clear to you?
Yes, sir.
Is it very clear?
Yeah, clear.
Right. Dilini?
Yes, sir. Everything is clear.
Okay. Do you allow me to wind up? We have, a couple of 25 minutes, right? Normally what we, allow this time for you to raise questions. If you don't have questions, right? So, shall we wind up?
Okay, sir.
Okay, sir.
Right. Because, I see, very few participants, as usual. Okay, then good night for everyone.
Good night, sir. Thank you,
Okay, good
sir.
night. Good night.
Thank you, sir. Good night.
Okay, you're welcome.